So, John, thank you for doing this. We welcome the group, and I'm going to provide control to you to take us through the next hour.
Perfect. Thank you, Matt. Thank you, everybody, for being here today. We're going to cover, as you guys probably expect, critical aspects of securing your ideas through patent law and common misconceptions and myths. But I'm not going to start there because there's this first misconception is that what's holding a lot of inventors back is actual knowledge, that it's legal doctrine, and that's what's holding most inventors back from pursuing their ideas and most startups and small companies from going forward. And that's actually the furthest thing from the truth. And my book, Escaping the Gray, I talk about that quite a bit. And that's we'll talk about more about this later. But what's holding most inventors back is actually their comfort zone and fear. And the fear, not just of failing, but the fear of being judged by their peers. And one of my favorite quotes is this by Theodore Roosevelt: "Far better it is to dare mighty things, to win glorious triumphs, even though checkered by failure, than to rank with those timid spirits who neither enjoy nor suffer much, because they live in that gray twilight that knows neither victory nor defeat." Now, later today, I'm going to tell you about a client of mine, Alex Gomez, that escaped this gray twilight that President Theodore Roosevelt was talking about. Alex dropped out of medical school to pursue his invention. But first, I want to initially thank Matt for the formal introduction. Yes, I'm a board-certified patent attorney. I'm an adjunct professor. I've been teaching for 18 some years, practicing for almost 25 years. But what I want to do now is take you guys back in time, beyond the formal introduction, and I want to introduce you to myself when I was 12 years old. And at 12, I was incredibly cool and stylish. And here's proof. And I was on a mission. My dream and sole ambition in life, was to take this Rubik's Cube and make it round. There's nothing I wanted more than to be the inventor of the round Rubik's Cube. And I had a sketchbook under my bed with page after page of drawings of my round Rubik's Cube. And I had taken a screwdriver to the cube, broken it apart, and there were pieces all over the house. My mom was constantly upset and yelling at me for the broken pieces of Rubik's Cube everywhere. But I kept working on my design, sketching it in this book that I kept under my bed, and everything was going well until one day my mom brought me to the mall, and there's this toy store called KB Toys. And I went to the aisle with puzzles and games where I'd always go. And what I saw there on the store shelf crushed me. Somebody had already created a round Rubik's Cube. And they came up with a better name, in fact, than round Rubik's Cube. They called it the Impossible. The Impossible. Even a better name than what I had. I still have the actual Impossible from gosh, I don't know, some 40 some years ago. And I was crushed. It felt like a kick in the gut. And, and I looked up at my mom, but I didn't cry. But you know what? My mom started crying. She had seen the sketchbook under my bed. She had watched me draw out these designs and put my heart into being the inventor of this round Rubik's Cube. And my mom's not one of these soft, gentle criers. She's loud. She's embarrassing. Back then, all your friends were at the mall, so I grabbed her by the hand and I dragged her out of that toy store. Now, those clerks had seen plenty of moms dragging crying kids out of the store, but never a child dragging their mom out. Now, children cry when they don't get what they want, and it's usually considered a bad thing. But there's a type of beauty to it. It's because they actually expect to get what they want. They actually expect their dreams to be within their reach. Now, something happens to us as we grow up. We start losing that natural confidence that we can get what we want. And we start dreaming small and dreaming safe and staying inside that gray twilight that President Roosevelt talks about. Now, people will keep you in that gray twilight if you let them. Oprah Winfrey was told that she's too ugly to be on television and that she should stick to the radio. Uh, Wayne Gretzky was told that he's too small and too slow to ever play professional hockey. Walt Disney, in fact, was fired by a newspaper editor, believe it or not, for not having enough imagination. Walt Disney, one of my favorite quotes from Walt Disney is this right here. I keep it in my office. I don't know if you guys can see it, but if you can dream it, you can do it. Now, how many of your dreams have you given up on because you don't fit this perfect mold? You either don't have the right amount of money, or you don't have, believe you don't have the contacts, or maybe you're from outside the industry where your invention is coming from. How many of them have you not pursued and given up on? That's the great twilight that stops most inventors, most companies, in fact, from innovating, because something might be outside their industry. What would happen if you ignored the naysayers and you ignored that doubt and proceeded with your idea anyway? This is what would happen. This is a quote by Mahatma Gandhi. First they ignore you, then they laugh at you, and then they fight you. Now, this isn't the entire quote. I'll get to that later. But first, I want to share my dream when the plan A to become the inventor of the round Rubik's Cube, the spherical Rubik's Cube, when that didn't work out, I always loved tinkering with things and taking things apart. And I decided to become an engineer. And in fact, I decided to go on to law school. But I didn't just want to be a patent attorney. I wanted to work at Fish and Neve. And if you're not familiar with this law firm, Fish and Neve are the lawyers that represented Thomas Edison with the invention of the light bulb, Henry Ford for the automobile, Alexander Graham Bell for the telephone, and the Wright brothers for the airplane. Fish and Neve was to patents and inventing what Muhammad Ali was to boxing, the greatest of all time. Now, I wasn't prepared like Muhammad Ali for a world that hits hard, for a placement director that told me, John, you don't have a chance at starting at Fish and Neve. This is the most prestigious patent firm in the world. They only hire from Harvard and Yale, and they only look at students that have done summer internships with them. Now, a summer internship seemed nuts to me. I was an engineer first. I went back to law school and had a full-time job working as a structural engineer. I didn't have the luxury like other students to quit for 3 months and go do a summer internship and then get my full-time job back. But you know what? I did finish at the very top of my class in law school. I aced the patent bar exam, and I ignored that placement director and went ahead and sent in my resume anyway. Since I'm telling you this, you probably think things ended up well. They didn't. I got this rejection letter, and it stung hard. It was like a kick in the gut. I couldn't sleep that night I got the rejection letter. I tossed and turned. And the next day at work, I left during my lunch hour to find a payphone. For those of you that even remember what that is. And I left the construction site where I was working at as a structural engineer, found a payphone, and I remember standing there with a quarter in my hand, trying to muster up the courage to call the law firm of Fish and Neve. And I finally did. And when I got Miss Rogan on the line, that's the person that had written that letter to me, I explained to her that her law firm's claim to fame is the invention of the airplane, the Wright brothers. These were two bicycle mechanics that invented the airplane. They didn't fit any sort of perfect mold, neither one of whom went to college. Only one finished high school. They had no investors. They were from Dayton, Ohio. And that's when I was interrupted. Mr. Rizvi, Miss Rogan said, hiring committee decisions are final. And I don't understand what your point is. My point, and the hair stood up on the back of my neck. I remember it like it was yesterday. And I said, my point is that your hiring committee has made a mistake. Miss Rogan, they need to look at my application again because they misjudged me. Click. I was nervous, so I hung up the phone. I don't know if it changed anything, but I felt better until 5 days later, I got another letter in the mail from Fish and Neve. My hands were shaking. I was a lawyer, remember? I thought I was being sued. Instead, it was the law firm of Fish and Neve asking me to come on board and join them as an attorney. And I did. First, they ignore you. Then they laugh at you. And then they fight you. Let's go back to that slide again. And when they fight you, I want you to fight back. And if you're creating something new, if your company is creating something different that's never been done before, I need you to fight back. Your idea was given to you for a reason. There's no shortage of inventors that have come from outside an industry and completely changed the industry. And that's why I became an attorney. That's why I went into patent law. But I started at this law firm of Fish and Neve. And at first it was amazing. I was making more money than I ever imagined possible. I was living in New York City, learning from the best patent lawyers in the world. But you know what? Money will fill the hunger in your stomach, not the hunger in your soul. I wanted to work with inventors. But the 5 years that I was at this law firm, not once did I meet with an inventor. I was meeting with MBAs and corporate lawyers and basically moving paper around and working in documents so far removed from the creative streak of ingenuity of a new idea. That's the whole reason I became a patent attorney in the first place. Even still, somewhere deep inside me was that 12-year-old boy that dreamed of being the one that took this Rubik's Cube and made it round. I wanted to quit. I wanted to quit and start my own law firm representing inventors. But what I wanted was the Steve Jobs and Bill Gates of this world. But I wanted them before they were Apple or Microsoft. And when I spoke to partners at the firm about my idea, they said, John, you're nuts. You're crazy. This is career suicide. This was around the 2000 election fiasco. They said, there's no ideas that come out of Florida. You guys cannot even figure out how to get a voting booth correct. And this was before people really understood the power of the internet and that you don't have to have a lawyer in your backyard. You don't have to look for a lawyer the same way you look for a pizza restaurant. And they ridiculed my idea. But you know what? I didn't want to work helping companies like IBM get their 10,000th patent. There's no passion for me in that. And I quit and I never went back. Now, that small law firm of mine that I was told wouldn't survive, I was told they would hold on to my resume in case I ever wanted to come back. Well, I didn't go back. But 2 years after I left, the law firm of Fish and Neve was no more. They went under. And today, they're little more than a historic footnote. But my small law firm, some 20 years later, has grown beyond my wildest expectations. And for the last 4 years in a row, we've been on the Inc. 5000 list of fastest growing private companies in America. And this past year, we were on the Law Firm 500 as the 53rd fastest growing law firm in the country. I believe that my reason for being born in this world is to help show innovators, inventors, small startups, that you don't have to fit a perfect mold to bring a new idea into the world. Elon Musk was not by any means the perfect candidate to have commercialized the electric vehicle. Where was Ford? Where was Chrysler? Where were these companies that had hundreds of years of history and billions of dollars of taxpayer funds? Why was it Tesla that changed the way electric vehicles are viewed and basically changed the course of history of the automotive industry? It's because an inventor can change the world simply with their idea. And I told you at the beginning about my client, Alex Gomez. I want to go back to Alex again. Alex came to my office frustrated. He was a medical student, and he's found that in hospital operating rooms, when doctors' surgical instruments would get fogged and the lens wouldn't let the doctor see what they were doing, they would take this instrument and basically rinse it off, sometimes under a faucet, sometimes they'd dip it in a flask of water, and then surprisingly put that instrument back into the patient. And in Alex's mind, this was septic. It had bacteria. It was causing patient deaths. But you know what? Unfortunately, there was no liability because every patient signed a waiver before any significant operations saying that all medical procedures come with a risk of infection. But to Alex, this was the preventable risk of infection. There's no reason to take a surgical instrument, rinse it off in water, and then put it back into the patient. So he came to my office with this contraption. He put it on the corner of my desk. It was a surgical lens defogger, a simple device, little more sophisticated than a rear window defroster on a car, except this was specifically made to help surgical instrument lenses not get fogged. And the prototype was a crude prototype. He literally put it together in his garage. He pointed to it. He said, "John, I don't care what they say about me." And they said things about him. They called him a dropout. They ridiculed him for having never finished medical school. They laughed, thinking somebody that hadn't finished medical school could possibly think that they're going to improve the way surgeries were conducted in hospital rooms. Alex thought perhaps it was just his hospital where they had this technique of rinsing off the lens, but he found that this was done in the top hospitals throughout the country. Nobody was worried about the risks of infection. There was no liability for patients getting a bacteria infection as a result of a surgery, and all the patients signed waivers. This didn't sit right with him. He said, "John, I don't care what they say about me. This idea needs to go out into the world. Please file my patent for me. Win that patent for me." And I filed for a patent for Alex Gomez. Now, 2 years after I filed his patent, he was able to sell his idea to Medtronic for $100 million. $100 million. And here's that quote again. "First, they ignore you," which they did. Then they laugh at you, which they did. And then they fight you, which when he started finding success, that's exactly what happened. And I promise that this wasn't the full quote. Here's the full quote. "Then you win. Then you win. But in order to win, you can't give up on your idea." But we're conditioned to do that. We're conditioned to think that weighing the costs and benefits of proceeding is the prudent thing to do. Looking at the risks of proceeding with our idea and not proceeding and staying with within our comfort zone. If we're an individual, staying with our 9-to-5 job. If we're a small startup, staying in that industry that we're a startup in is the safe, prudent thing to do. That's the smart thing to do. At least that way there's no risk. But you know what? They say the greatest risk in life is dying. I don't believe that. We're all going to die someday. The greatest risk isn't dying. The greatest risk is dying with that unfulfilled idea still suffocating inside us. One of my favorite quotes is this quote by John Ruskin, English writer. in the end, it doesn't matter how much you know, what you think, or what you believe. In the end, the only thing that matters is what you do. And if you take away nothing else from this presentation, as we go into the actual critical aspects of securing your idea, I want you to remember that it's the action that's going to change everything. Because I've been teaching for 20 years at Nova Law School. I've been giving seminars about patents and trademarks, and I've had inventors time after time come to me afterwards, not proceed with an idea, and it wasn't the lack of technical knowledge that did it. It was that comfort zone, that great twilight that President Roosevelt warned us about. And for that, all of you, especially if it's an area that you proceed with outside your industry, you're going to hear from experts. I just want to show you a few slides of how often the experts have been wrong. Everything that can be invented has been invented. Charles Duell, commissioner from the United States Patent and Trademark Office. There's no reason anyone would want a computer in their home. Ken Olsen, president, chairman, and founder of Digital Equipment Corp. The wireless music box has no imaginable commercial value. Who'd pay for a message sent to anybody, sent to nobody in particular? The telephone has too many shortcomings to be seriously considered as a means of communication. The device is inherently of no value to us. Western Union, an internal memo. Finally, something academic, which I love for the students, especially in law school, because law school grading is very subjective, and be surprised how much of it is. But here's concept is interesting and well-formed, but in order to earn better than a C, the idea must be feasible. This was a Yale University professor's response to Fred Smith's paper for overnight delivery. 7 years later, he went on to found Federal Express. Finally, market research reports say America likes cookies, crispy cookies, not soft and chewy cookies like you make. Rejection letter to Debbie Fields, the founder of Mrs. Fields Cookies. With that, let's start with a patent, and that's what we're going to cover today. Here's the formal definition. It's a right granted by the government to an inventor to exclude others from making, using, selling, or importing an invention into the United States without the inventor's permission. A lot of people don't realize that that a U.S. patent is incredibly powerful to prevent imports. And so that's one of the myths I want to dispel. There's a lot of worry about imports from China or from overseas flooding the U.S. market. And I don't have the money to pursue a patent throughout the world, so I'm not going to pursue one at all. Well, a U.S. patent can be used to prevent imports. And then another thing, yes, if you have the money to enforce your patents, patenting is great. But what if you don't have the funds to do that? I have a client that has stopped 500 infringing products off of Amazon and Shopify without spending a single dollar in legal fees. These online platforms today have administrative procedures where if you believe your idea is being infringed on, you don't have to hire a lawyer. Follow their process, upload proof of your patent, and they don't want to be sued as a contributory infringer. Amazon does not want to be sued as almost, the criminal equivalent is an accessory to a crime. In the patent sense, if you're not infringing yourself, but you're helping a company infringe, which is what Amazon could be seen as doing, you are responsible as well for the infringement. So what Shopify, Amazon, all of these online sales platforms have done is made a simple administrative procedure. The inventor uploads a copy of their patent, and the allegedly, it's not even a proof of infringement, allegedly infringing product is automatically taken down unless they can come forward with a legal opinion from a patent attorney saying that they're not infringing. Now, 9 out of 10 times, they never come back. So the ones that come back are the ones that have a legitimate case that they're not infringing. But if you can prevent 90% of infringing products without spending a cent in legal fees, like how phenomenal is that? it's an incredible benefit of the patent, design patents as well as utility patents. But I want to talk about the difference, and then I want to talk about some simple examples of both design and utility as well. Utility patents protect the use of an invention. Typically, they're for a machine, manufactured article, composition of matter, or a process, something practical that does something better. Utility means use, so it's a patent that protects the use. Now, a design patent protects the visual characteristics of an object, of a product, the way something looks, if it doesn't have any unique features, any unique use that makes it better. Plant patents, we're not going to talk that much about. It's for a newly developed plant. Let me grab some product samples real quick, and then and I'll talk about those. And we'll talk about whether they're utility or design and how the difference works. Give me just a minute. Okay. Let's start first with relatively simple everyday product, the Post-it note. And you might ask yourself, well, what's so like unique about it? This is not rocket science. This is not complicated. And that's another myth, is that ideas have to be somehow super complex in order for an inventor to get protection. A Post-it note is simply a type of removable glue on paper, and that's all it is. Now, this would be a utility patent because it's not the look of the invention that's being protected, it's the function. Another idea, simple product, again, it's been around forever, a sleeve on a cup of coffee. This is another example of a utility patent. It's not the look that's being protected, it's the function itself. Finally, well, I'll show you an example of a design patent. Here's a Frisbee. Obviously, the usefulness, the utility is that it just goes through the air. It can be caught. It's a game. But in this case, I'm going to hold this up. You can see particular indentations on the Frisbee itself. Now, if the inventor believes that this is somehow helping with the use, then this is protected with a utility patent. It protects the use. However, even if the use is not unusual and doesn't do anything, any benefit from a utility aspect, you can still protect this with a patent. It would be a design patent to protect the look. And then finally, I want to point out this as oh, by the way, the Jay Sorenson's, the inventor of the coffee cup sleeve, he was able to license this idea for $1 million a year for over 20 years for a cardboard sleeve that goes over a cup of coffee. Ron Brown was tired of going into restaurants or even in his home and having to hit the bottom of a bottle of ketchup to get the ketchup out. So what he decided, you might not think it's brilliant in itself, but he took the label on a bottle of ketchup and reversed it, put it upside down. Now, the way the human brain works, you just have a hard time putting something like this on a counter in this orientation. You naturally want to turn it around and store the bottle this way. So he has a wider bottom so that people will store the ketchup bottle in this direction. In addition to that, he's used a plastic as opposed to glass so that you can squeeze the bottle. That's the second feature. And then the final feature is a leak-proof, I'm going to hold this up, hopefully it can be seen, a leak-proof nozzle. Now, the beauty is that neither one of these ideas by themselves are protectable. So he's got like idea A, idea B, and idea C. All three of them individually, there's nothing unique. There's nothing patentable simply about reversing a label, putting a label upside down. There's nothing unique about a squeezable bottle. Ron Brown wasn't the first to invent that. There's nothing unique about a nozzle that's drip proof. This is right on top of my laptop here. So It is, believe me, it's leak proof. I've tested it. But if you take three already known ideas that individually there's nothing unique about them, you combine them together, you now have patentable subject matter. And 90+% of all patents are combinations of existing products, combinations of existing ideas that have been put together in a new way. Now, let's go into the term of a patent and how long a patent lasts. So utility and plant patents have a term of 20 years from the date of filing. So once you file for the patent, for 20 years, you have exclusive rights to that idea. And sometimes those rights establish you so well in the market that your product name almost becomes synonymous with the invention itself. An example of that is years ago, the Xerox machine. Xerox had patents on their copy machine. They were the first to get a patent. And if you wanted a copy machine, it had to be a Xerox because they owned the patent on it. And because of that, the term Xerox almost became a verb. Like you, instead of photocopy something or copy something, people would say, can you Xerox this? That's how powerful this 20-year term is, because it gives one inventor exclusive rights for 20 years. Now, design patents have a term of 14 years from filing. What do you need to get a utility patent? There's three requirements. You need utility, novelty, and non-obviousness. And we're going to go over these, and I'm going to go over the simple examples I showed you earlier and talk about how each of them were able to show utility, novelty, and non-obviousness. First, before I do that, one thing, interesting fact I forgot to point out about this idea, Ron Brown was able to sell his patent for this combination of the three different features: the reversible label, A, B, and C, the reversible label, the squeezable bottle, and the leak-proof nozzle. That combination was patented and sold for $13 million. This dispels another myth that I'm constantly seeing that's just not dying. And that myth is that in order to get a patent, your idea has to be like a cure for cancer. And I'm probably dating myself, or it's got to be like a flux capacitor. You have a flux capacitor, now you can get a patent. That's coming from the movie Back to the Future. You don't have to have an idea that's that complicated to get an incredible patent and have an incredible monopoly in the market. Jay Sorensen's cardboard sleeve on a cup of coffee was not is not rocket science, right? You could go to any university, ask a group of engineering students to come up with a design that provides this, and they would all be able to do it. So it's not a complex idea. But I want to since we on that topic, let's talk about utility, novelty, and non-obviousness. Utility in the patent sense means usefulness. It's the usefulness of an idea, and the patent office applies that extremely broadly. So it's not a tough requirement to meet, but as long as your idea does what it purports to do, it will pass the utility requirement. So if this sleeve purports to help keep your fingers from getting too warm or provide a better grip, whatever it is, as long as there's a reasonable purpose and the patent and an examiner can look at it and on its face it appears to meet that requirement, you meet the utility requirement for the patent. Novelty simply means that it has to be new. So anything that's not been done before. And one misconception is that you can import ideas into the United States because they haven't been done in the United States. But the law doesn't require that. The US patent law requires that it has to be a new idea, period. Not just new in the United States, new anywhere. So if you in order to get a patent, you have to have a new idea. You have to be the inventor of the idea. Importers are not inventors. And the final requirement is non-obviousness. Your idea cannot be obvious over something that's already out there in the marketplace. And that's the one that gives most inventors trouble, because when you're an expert in your field, what seems relatively easy to you, you may assume that it's obvious, but the requirements for obviousness are difficult to understand. There's a lot of case law that goes into obviousness. I would not give up on an idea because you think it is too obvious. Like how complex would it seem to be to take the prior art, which is the formal term for how did people do things before the invention. Before you had the Post-it note, you'd simply take tape and paper, and that was the alternative. So it wasn't, this wasn't seen to be obvious. And 3M was able to get a patent on this. The sleeve, they were able to get a patent on. And then finally, you combine multiple ideas together in a unique fashion, like this inventor did, Ron Brown, and you're able to show patentability. So you show utility, novelty, and overcome non-obviousness. The final topic I want to cover is a major change in the patent law that took place in 2013, and that's a change from the first to invent to a first to file system. Prior to 2013, the US was one of the few countries in the world that was on a first to invent standard. Whoever invented the idea first owned the idea. However, that was changed in 2013, and this is a huge change in the law that impacts so many smaller startups and smaller companies who are not aware of the change to first to file. Today, whoever files that application earliest owns the idea. So inventing first, and there's a lot of misinformation out there about documenting how you came up with your invention, keeping your receipts, getting witnesses to sign your laboratory notebooks, or recording evidence of when you came up with your idea. None of that is going to help if you don't file the patent first. Now, it would help prior to 2013 under a first to invent system. But today the US is on a first to file system, which is the same as the rest of the world. And today it's a race against time to the patent office with whoever files that application first. Now we'll go to the patent first on Jay Sorenson's patent on the Java jacket, or the cardboard sleeve, and look at those three requirements: utility, novelty, and non-obviousness. So utility, it clearly meets that. Novelty, is it new? Yeah, certainly it's a new idea. Does anyone remember, and this is for, if you raise your hand, our moderator can unmute you, what was the alternative to this coffee cup sleeve? How were people dealing with the problem this inventor is addressing before the invention of the cardboard sleeve? What was their prior solution? And I'm gonna, if anyone raises their hand and wants to volunteer, Matt, you're a co-host, and Crystal is as well. You can unmute them, but otherwise, I'm going to take a shot at drawing what the prior solution was. Oh, Herman, go ahead. Herman's got his.
Can you hear me?
Yes.
Okay, you either use some extra napkins around the cup, or you double up on the cups.
Perfect. So that's two options. And I'm going to hold this up. Option A is a napkin. Option 2 you mentioned is a double cup. Now, what's the downside of double cupping? Can you think of why that fell out of favor?
Increased cost.
Increased cost, and the environmental movement, right? The green movement. It was filling up landfills with double cups. It was wasteful. Yep. There's one other solution that Herman, you didn't mention, and I'm gonna try to draw it, but every once in a while I'll run in at a rest area into this solution, and this is little cardboard ears on the side of cups that would fold out, and you can use that as an alternative to the sleeve. Now, but what killed this idea, believe it or not, was technology, because more and more people were working in front of computer screens and drinking coffee, and they don't want their eyes to leave the screen. So when you want your cup, you just want to grab for it, take a sip, put it down. The problem with this, there's multiple problems. One was that you had to take your eyes off your screen, put your fingers through the ear pieces, whatever these are called, take your sip, and then disengage, go back to typing, and then you have to go through that every time you want to take a sip. It was a pain. That was a big downside. Another one, of course, was they weren't stable. Like even if you had your fingers in here, the coffee cup would still shake. Minor differences, but such an incredible, I guess, commercial, like, I guess, my God, like what a huge win for the inventor by solving a small problem. And that brings up another misconception. The issue does not have to be earth-shattering. Like, how difficult is it to take paper and tape and use that instead of a Post-it note? It's not solving a huge issue. The world was not suffering in silence because they had to hit the bottom of a ketchup bottle until Ron Brown came along with his invention. So that's the utility, novelty, non-obviousness for using the sleeve on a cardboard cup as an example. Just going to go through the Post-it note again. Here's the patent for the Post-it note. Again, utility, it's clearly useful. Novel, it's new. Nobody had done this before. And then it was seen to be non-obvious as well. And then we've already talked about Ron Brown's patent on the upside down squeeze bottle. So with that, I know, Matt, you had asked for 15 minutes of Q&A at the end, and we're exactly on time. So Perfect. If you have questions, we'll open up the floor for questions. Before that, anybody that wants, this is my life's work, is my book, Escaping the Gray. And I also have a copy of Think and Grow Rich for Inventors that's based on the classic business book by Napoleon Hill, Think and Grow Rich. Crystal's my assistant here at the office. If you want a copy, the email address is on this slide. Email her and your physical mailing address, and we'll mail out a copy of both of these books. No cost, no shipping and handling, no cost whatsoever. I believe it's for if there's an idea out there that somebody is not pursuing because they're in this gray twilight that I spoke about. If this book helps you get over that gray twilight, I would be that's payment enough for me. So if you have an idea, keep it confidential because it's we're on a first to file basis in the United States, but don't not pursue it because you're outside the industry or you think for some reason or other you're not the right person to bring this idea into the world. So with that, if there's any questions, raise your hand and I'll stick around until 1 o'clock.
Very good. Well, thank you, John, for doing this. Anybody have questions that we can get answered for you from John, our expert? Anybody thinking about wanting to patent something, have a question that you'd like to know?
Oh, I see Fernando's got his hand up. I don't know.
Howdy, how's it going?
Good. How are you?
Good. Hey, John, thanks for the presentation. It was
Yep.
really good.
Thank you.
So my question, I guess, is related to what the best steps are to take when companies and manufacturers are thinking about their product, and what are the easiest or almost convenient ways to start down this journey of considering IP, patents, trademarks, whatever it might be. What would you recommend be their first sort of initial step into this world?
Yeah, so the first step would be to is what not to do, is like, and it's the most tempting thing to do is to see what others that understand the problem think about the idea. right? So, you know, and I hear that a lot. Like, I don't want to go spend money on a patent if it's a dumb idea. And before 2013, when the world was on a first to invent basis, that was fine. There's no risk to that. As long as you had some evidence of coming up with the idea first, you had a fighting chance of winning rights to the idea. But now we're on a first to file. So the first thing not to do is don't discuss the idea with anyone, and start compiling a list of exactly what we did here. What are, without your idea, what are the other options? And there's always other options. I don't want anybody to say, well, there's nothing like my idea out there. There's always something like your idea. It's addressing the same problem, maybe in a completely different way, but, you know, ultimately, you know, the bicycle is an alternative to a car. So you can't say, if you're the first inventor of the car, well, there's nothing like my idea. There is something like it. So make that list, no matter how painful it is and how unique your idea is. There are other alternatives that already exist. Get those alternatives together, keep your idea confidential, and then go see a patent attorney and have a formal patent search done. If you want to search yourself, I would rely on the old-fashioned physical searches. Like, go by, if it's a to use a simple example, if it's a hunting, fishing, recreational product idea, go to Bass Pro Shops physically and look at store shelves to see what's out there. Doing online searches is incredibly risky because you may type in terms that reveal what the idea is. And there's few search engines that don't have their database being constantly mined for search queries. There's marketing companies that mine search queries for data. That's why when you type something in for, you know, that's why you see these ads that follow you around from website to website, because they know what you're searching for. You type in flowers, or sometimes even Gmail revealed that they scan emails for certain terms, and then and advertisers can use that to help them identify potential buyers for their products. And I think the example was the term funeral. So if you have funeral in email, the recipient and the sender could likely see products advertised that go hand in hand with the funeral. Say flowers, you might see an advertisement for flowers, and that's the risk. But if you type in actual terms looking for your idea, an example is glow-in-the-dark kite. Say you come up with a glow-in-the-dark kite idea, you want to know if it's out there. You know, of course, one risk is that you may not use the right terminology. Like, patents use terms that are not intuitive. It might say illuminescent flying novelty toy. Might even avoid the word kite. Might even avoid the word glow and use terms like luminescent or something. But the other problem, the bigger problem, is that a term like glow-in-the-dark kite reveals exactly what your idea is on a public search engine. Incredibly risky. So I don't know if that's, Fernando, if that, a lot of the advice of what to do when you first have a new idea is advice of what not to do. So those are two of the biggest fears, is doing online searches and discussing your idea, trying to see if anybody has, you know, sees a benefit to it. Yep.
Awesome, thank you. I wanted to also say, if you guys have any additional questions, maybe you haven't thought up of it during this time, you can always email it over to me and I can connect you with John and anyone on the Patent Professor team, so that way you can get your questions answered. Thank you so much, John, for dedicating your time for this wonderful webinar. It was a lot of great information, a lot of inspirational things that I definitely am planning on taking with me. So thank you so much for that.